Hello, everyone, and welcome to Uncivil Law, where, as always, we learn from those misfortunes of others. As always, I hope you'll enjoy this live legal education content, and today will be the day I earn that subscription. For today, we're doing just a very quick little follow-up to a stream that was just completed by a new friend of the channel, Charlotte on the Web. Charlotte on the Web was covering a document relating to discovery disputes in the ongoing issue between Todd Chrisley and Without a Crystal Ball, and talking about it, and people wanted to know a little bit about what was going on. So I haven't read the underlying documents, but that's okay. I watched 10 minutes of the stream, so I have a pretty good idea what we're talking about, right? Because I know stuff. Anyways, let's talk about what is happening and what is not happening. Okay, so here's how I understand the factual picture of the stage of the case we're at. This is how I understand the stage of where we're at. All right, so there's currently a motion to dismiss pending, and also discovery is happening at the same time. Now, general discovery, like just totally open discovery happening while a motion to dismiss, is basically unheard of. However, limited discovery for the purposes of a motion to dismiss, or limited discovery for the purposes of a motion for summary judgment, while not unheard of, is also unusual. So it's not something that's impossible, basically, like a general discovery. If we were in general discovery with a motion to dismiss pending, I'd wonder how the hell we got there, because that just seems totally bizarre. If we're in a limited discovery for the purpose of motion to dismiss, I would be surprised, but not shocked, right? Because it's unusual, it's rare, but it's allowed for, right? So sometimes the court will order limited discovery. So what is discovery generally? Well, discovery is the formalized name for the process of getting stuff from the other side. This can be in the nature of other things. This can be in the nature of depositions. It can be in the nature of interrogatories. It can be the nature of give me documents. It can be the nature of give me videos. It can be the nature of give me stuff. Give me stuff that you have so that I can make my case, which you can do in a civil case, right? You can do that in a civil case. And also, the defendant in a criminal case can do it for the government, but not the other way around, right? Not the other way around. Although there is technically some limited disclosure aspects in criminal law, but we don't have to get into that right now. So, the technicalities are where things get interesting, but let's just say it doesn't happen and call it a day. Anyways, so apparently there's a discovery dispute between Todd Chrisley and Without a Crystal Ball. Without a Crystal Ball has apparently not responded to some of the questions, and apparently responded to the questions that she did respond to with apparently only public documents and not private documents. So, first question is she necessarily, by this, in violation of the discovery? And the answer is no. She can't produce what she doesn't have, right? So if she says, I have no responsive documents, and that's true, because if she's lying to the court, that's a whole other set of problems, right? But if it's true, she has no responsive documents, then, she just doesn't have responsive documents. That can happen. I mean, I just don't have that piece of information. I don't know what to tell you. Someone else may have that information. I don't have it. Can't help you, right? I don't got it, don't know what to tell you. So if she doesn't have it, she doesn't have to disclose it. If she's disclosing everything she has, even if all that's public information, then that's all there is. There might be other documents in the world somewhere. There might be other videos in the world somewhere. But if she doesn't have them, she can't produce what she doesn't have, right? So that's step one. Step two, she's apparently trying to claim journalistic privilege. I'm not even going to begin to get into whether or not she does or does not have journalistic privilege. As I sort of indicated in my stream with Charlotte on the Web when we were discussing this, journalistic privilege is all over the map in terms of its degree of existence. Not every place recognizes it at all. Some places that recognize it don't recognize it for all people. Some only recognize it for more formalized outlets, and some only recognize it to this degree, or some only recognize it to that degree. Journalistic privilege is all over the map. So does she have journalistic privilege? I don't know. I guess I could go read the statute and try to figure out whether or not she squeezes in the statute or not. But yeah, so this is the difference between like being a journalist, just claiming to be a journalist, and falling in with journalistic privilege. And also, incidentally, why the term journalist doesn't mean stuff. Because, again, journalistic privilege doesn't exist everywhere. And to the degree it does exist everywhere, it doesn't necessarily exist in a total form, nor does it exist with respect to everyone. So there could be someone that you and I and everyone else would agree is a journalist, but that doesn't necessarily mean that they're covered by a privilege, assuming one exists, because that's a lot of assumption, right? So when you're asking a question like, is Katie Joy a journalist for the purpose of the journalistic shield statute, we got to go read that statute. We got to go read it carefully, and we got to go read the case law, because unlike basically of any other privilege in existence, where it is more or less uniform across the country, not to say it's completely uniform, but I can give you a generalized rule, and I might be wrong, but not that wrong, because it's generalized. In journalistic privilege, I'm just throw out my hands and be like, I don't know, because it's all over the map. Maybe she does, maybe she doesn't, I don't know. Now, what is interesting is that in many states, and again, this is a question of individual state rules. In many states, you would have to provide what's called a privilege log. So what's a privilege log? Well, as the name suggests, if you have privileged information, you have to disclose that you have the information, but you don't have to disclose the information. You just have to disclose you have the information, not the information. There's decidedly a difference between these two things, right? So if I have documents that are responsive, again, in some jurisdictions, because the rules are different in practice from place to place. But in some jurisdictions, I would have to disclose a privilege log. So I, as an attorney, like in response to your motion for discovery, I might have to do a privilege log, which would say like, okay, here's some documents I have that are responsive. And also, by the way, here's a list of all the documents I'm not going to give you. And here's kind of generally speaking what they kind of vaguely talk about. Because again, I can't tell you what they talk about because they're privileged. But I have to give you enough information so that you can meaningfully dispute the privilege, because maybe it's privileged, maybe it's not, right? So you can meaningfully dispute it. So I have to give you enough information to allow you a meaningful opportunity to respond without telling you what the information is. Fun. All right. And then, of course, all this, in terms of these discovery disputes, are not atypical. And also, attorneys kind of routinely claim them. Maybe routinely is unfair. Frequently claim them. How about that? Yeah, the idea of they're not just participating in the discovery, they're not participating fairly. This is to a judge just so much back chatter, because this happens enough and it's annoying. Judges hate this shit because discovery doesn't have to involve the judge at all. And the judge would just be happy if it didn't involve them at all. It's like, I don't have to be involved. I don't want to be involved. If you're making me involved, I'm going to be irritated, is usually the attitude of most of the judges. Generally speaking, right? Now, so what will happen? Well, they're filing some motions, it looks for compelled discovery, which is the next logical thing, right? Okay, well, so we had the request for discovery. They're not playing nice with others. Judge, can you force them to play nice with others? And then the judge has to get involved in this and decide, okay, are they playing nice with others? Do I have to force them to play nice with others? And begins to hate their life usually a little bit, because it's like, I have so many better things to be doing with my time. I could be looking up some case law and doing some research on some interesting case or interesting legal principle in some other case that I'm dealing with. But now I have to babysit this bullshit is probably a pretty typical response. So yes, the idea of people not cooperating discovery is not unheard of. The idea of people claiming that people didn't cooperate, even if not necessarily true, incidentally, is also not unheard of. So these sort of tactics in discovery are common and to most judges deeply irritating. So yeah, the next logical step here would be a motion to compel, which is probably what we just read, I guess. Yeah, it's a motion to compel. Please make them cooperate. And so the judge now is going to probably have to get involved and hate their life a little bit secretly inside and get involved about, okay, all right, now Joey, did you hit Anna? Anna, did you make fun of Joey? Okay, now kids, now that's not nice. You shouldn't make fun of people and hit people. Joey and Anna, okay, time out for everybody is a very likely result in all this. And yeah, she doesn't have to disclose what she doesn't have. So she said, for example, Katie Joy at one point said, like, I don't know the name of the person I talked to. If she doesn't know the name of the person she talked to, that is a perfectly valid response. Maybe she was told the name and simply forgot. And remember, forgetting is a defense, because I don't know it now. I can only disclose what I have. Maybe they told me at the time, I just don't remember. I can't disclose it because I don't know, because I forgot. Right? I can't disclose what I don't have, so if she doesn't remember, fine. Okay, that's a perfectly valid response. That's fine. That's good. All those things, that's fine. So yeah, this is also why on the channel I described it as a bit of a nothing burger in the grand scheme of things, because these are not unusual. These sort of discovery slap fights, and that's kind of what it is. It's like two kids slapping each other, and basically the judge just getting really irritated at possibly everybody, and then drinking a lot. This is possibly the results. So will there be sanctions? It's unlikely there will be sanctions, right? The most logical result that would emerge from this is the judge ordering them to play nice. It's like, okay, you didn't play nice. Start playing nice now. I'm watching you. Start playing nice, right? That's the most logical next step. And then if they stop and they continue not to play nice, then we get into escalating sanctions past that. But yeah, no one's going to jail. No one's going to contempt. The most logical thing is the judge just burying their head in their hands and saying, okay, just turn over the documents. Why am I here? Just turn over the documents for the love of God. Just turn them over. Why am I here? That's probably the most logical result. So, yeah. So hopefully that is all good in terms of that. So, yeah, I mean, yeah. It's a bit unusual. Discovery is ongoing while the motion to dismiss is pending. Limited discovery is not unheard of. If she doesn't have the information, she doesn't have it. If it's privileged, or at least arguably privileged, fine. She can say it's privileged. In many jurisdictions, she'd have to provide a privileged log that would describe it in at least a little bit more detail, which it doesn't look like she did, so maybe the state doesn't require it. But that seems to be slightly odd. That is missing. Whether or not she is covered by the privilege, I can't even begin to intelligently comment, because journalistic privilege is all over the map. All over the map. The federal system doesn't recognize it at all, by the way, incidentally, just in case you're curious. Right? The federal government does not have journalistic privilege. It doesn't exist. So if the New York Times is in federal court and they ask, what are your sources? Right? The New York Times has to answer that question. Now, they probably won't, and they'll probably go to contempt, and they'll probably go to jail. It's happened before. Several times. But yeah, reporters have gone to jail, including like New York Times reporters have gone to jail for refusing to reveal their sources because there's no journalistic privilege in the federal system. So it happens. Whether or not that's covered here or not, or who knows. So let me answer a few questions and see where we're sitting. I'm going to rain on your parade. Not particularly. I just, I don't mind you covering things, Charlotte, as always. It just, to my mind, what I read, it just seems like a very typical, I have face powder on my hand. Oh, thanks. Powder on my hands. Thanks. And I'm not raining on your parade. It just, to me, doesn't strike me as particularly interesting. I look at it and I'm like, yeah, it's a day that ends in Y is kind of how I look at it. But, that's me. Oh, yeah. Someone asked about 7M. I don't think there's any relation to this and 7M. I really, really don't. I don't think that at all. This case has been ongoing independently of this. This seems like the right timeline for these kinds of things. So it doesn't surprise me this is happening. I really don't think that the recent 7M lawsuit in any way is influencing the action of Todd Chrisley or his attorneys. I'd be very surprised. Again, it's kind of neither here nor there. I just don't think it's a factor. It just seems like the normal, albeit irritating operation of how things normally progress. Read the statute. Okay, I'll pull up the statute and I'll try to interpret it on the fly. This will be fun. Also, thanks for a nice kitchen. Thank you. I hope you like the blue light. I'm experimenting with different light colors, and the blue is pleasing me. I just got color changing bulbs like 3 days ago or something. I know I'm a little late to the party, but the color changing bulbs are kind of cool. I like them. I should have gotten them a long time ago. She'll go up her husband if she thinks he'll get her something. That's funny. Melanie says, what would happen to her if it's found out she's lying and Todd is able to prove that? Well, I'll just answer the first half of the question. If it proves that, if you can prove she's lying, then she's in contempt, right? I mean, she has to cooperate with the process, whatever it is, right? The fact discovery is ongoing at all is a little unusual. The idea of limited discovery is not unheard of, although somewhat rare. But okay, if it's and generalized discovery, although I can't imagine how that would occur while a motion to dismiss is still pending. If for some god-awful reason it was, right? If for some god-awful reason it was, you have to, participate in the process. You can't just say no. You have to participate. Maybe she is participating fully. Maybe Todd Chrisley is a whiner. I mean, without getting into it, without knowing it, you see, this is where we don't know, right? Because we don't know what she's withholding, assuming she's withholding anything. We don't know what she's withholding. We don't know the degree that's privilege. We don't know if Todd Chrisley's just being a little biatch, which he might very well be, right? But to me, this looks like a somewhat routine, ordinary, annoying discovery dispute, and the judge usually hates everyone and usually wants to just kill everyone in sight. Can this be used to shut down our platforms? No, not really. Yeah, that's Stephanie's right. Not really. All right, so let's look up the Minnesota statute on journalistic privilege and try to interpret this on the fly, which is dangerous because case law might dominate over this. And this happened in, I think it was Oregon. It happened in one of those states. I want to say Oregon, or maybe it was Colorado, where the Supreme Court of the state ultimately ruled that bloggers aren't covered by the journalistic privilege, even though the statute doesn't seem to suggest that. But then against a question of law, that's what the Supreme Court is for. So we're going to try to interpret this on the fly without looking at case law, which is just incredibly dangerous, especially, again, in this particular area. It's dangerous because it's so all over the map and so unsettled, right? Normally reading a statute on the fly, I wouldn't get quite this nervous about, but this area of law is new. All right, it existed basically since yesterday as far as the law is concerned, so no one knows what the hell's going on, so it's a little bit dangerous to start talking about it. But we'll try anyway, because, why not roll deep? All right. Oh, Lord. Stephanie's sending me links. Thank you, Stephanie. You are awesome as always. Stephanie is best mod. Yes. Okay, so this is summarizing it. This is summarizing the case law. Okay. Ooh, it does disclose this text. Great. We can use this. Fine. Fantastic. Let's use this. This will be a reasonable basis for us to have a quasi-intelligent discussion with all the asterisks ever. I can't really do it with a printout on PDF, so we'll have to do it from the webpage itself. That's okay. I just have to readjust some boundaries in OBS. Give me 1 moment, please. All right. So I want to start with the text of the statute, which is not where this article starts. It starts with some case law and history and stuff and blah, blah, blah. But I want to start with the text, which, incidentally, as a judge, is always where you want to start. Not necessarily where you want to end, mind you. But you definitely want to start with the text. Right? That's a good place to start. That's a good place to start. Let's read what the statute says. That's probably a pretty good place to start. Okay. All right. So this apparently is the Minnesota Free Flow of Information Act. Fine. Public policy. All right. So here's where, okay. So the reason the public policy section is interesting, to me at least as a lawyer, or to me as a potential judge, the reason it's interesting to me is because if the legislature, anything the legislature passes is law, right? And so this statement itself is not operative. It's just a policy statement, but it's a policy statement, which means if we run into ambiguities along the way, right? And we're trying to interpret those ambiguities, right? Now, normally going outside the text raises a whole bunch of problems for a lawyer or for a court, going outside the text. But I don't have to go outside the text. It's in the text. It's in there. It may be not operative, but it's there. So if we run into ambiguities, then this will help us interpret those ambiguities. Outstanding. In order to protect the public interest and free flow of information, the news media should have the benefit of substantial privilege, not to reveal sources of information or disclose unpublished information. To that end, the freedom of press requires protection of confidential relationship between news gatherer and the source of information. The purpose of this section is to ensure and perpetuate, consistent with the public interest, the confidential relationship between news media and its sources. Okay. Except as provided in some subsection, no person who is or has been directly engaged in gathering, procuring, compiling, editing, or publishing of information for the purpose of transmission, dissemination, or publication to the public. That sounds pretty broad. I mean, that's pretty broad language, right? That's just basically all the people, right? This is why Katie Joy calling herself a journalist or not is kind of neither here nor there. Does it say journalists? No. It says no person. None of them. All of them, right? Nobody who's been directly engaged in gathering, procuring, compiling, editing, or publishing for these purposes. That's pretty broad language. Again, your mileage will vary substantially from jurisdiction to jurisdiction, and based on the case law, might even vary here. Yeah. Shall be required by any court, grand jury, agency, department, or branch of the state, or any of its political subdivisions or other public body, by either house of the legislature or any committee, officer, member, or employee thereof, to disclose in any proceeding the person or means from or through which the information was obtained, or to disclose any unpublished information procured by that person in the course of work, or any of the person's notes, memorandums, recording tapes, film, or other repertorial data, whether or not it would tend to identify the person or means through which it is obtained. That seems pretty damn broad to me. That seems pretty damn broad. That's a lot of protection. But, you know, it's the state legislature. State legislatures get to pass laws. If they want to write a law granting immunity to all the people for all the purposes in all the things, you know, okay. And if they want to do the exact opposite of that and say journalistic privilege is dumb, there is no journalist privilege, cough up your sources, peon, that would be fine too. These are the range of options that are available to the legislature. And apparently they went with the disclose no one, keep your secrets plan. Okie doke. Now we have some exceptions. Let's see if the exceptions swallow the rule, because sometimes that'll happen too. You'll read a section and it'll look really, really broad, and then you read the exceptions and you're like, oh, there's nothing left. This is why you got to keep reading. Subsection 1, disclosure, application. A person seeking disclosure may apply to the district court of the county where the person employed by or associated with a news media resides. See, right away we run into problems. Right away we run into interpretation problems. Right away we run into interpretation problems. What do you mean? Where the person employed by or associated with a news media resides. What do you mean that? A person employed by or associated with news media. Because when we went into the disclosure prohibited section, did it say persons employed by or associated with the news media? It did not. It did not. It said nobody. Nobody. Who's doing these things? We have legislative drafting problems, people. We have legislative drafting problems because in Part A, we said none of the people ever. And in Part B, it says, hey, you can apply in the jurisdiction of the person employed by or associated with the news media. What if they're not employed by or associated with the news media? Are they covered or not? I mean, the first section seems to imply yes. This section seems to imply no. Great work, legislature. That's just great news. That's fantastic. Okay, so there's that. Has the principal place of business or where the proceeding in which the information sought has been pending? Okay. All right. Subsection 2, disclosure allowed. The application shall be granted only if the court determines, after hearing from the parties, the person making the application, by clear and convincing evidence, has followed all three conditions. So clear and convincing is a technical term of art. It's more than probable cause. It's more than preponderance of the evidence. But it's not as much as beyond reasonable doubt. Okay. So here's the things we have to meet. There's probable cause to believe the specific information sought is clearly relevant to a gross misdemeanor or felony, or is clearly relevant to a misdemeanor, so long as the information would not tend to identify the source of the information or the means through which it was identified. I don't even know what that means. The information cannot be obtained by alternate means or remedy less destructive of First Amendment rights. I don't know what that means, incidentally, because, as I mentioned, there's no privilege in the First Amendment system. So what does it mean to be destructive of First Amendment rights? Because there's no privilege in the federal system. It doesn't exist. So forcing them to disclose everything would not be destructive of the First Amendment rights. So I don't know what that's supposed to mean. There is compelling and overriding interest requiring the disclosure of the information where disclosure is necessary to prevent injustice. I don't know what that means either. That sounds also pretty broad. So it has to be, the first subsection is the only thing that has any sort of weight to it at all. The first subsection is the only thing that has actually any weight. There's probable cause to believe it's clearly relevant to a gross misdemeanor or felony, or clearly relevant to a misdemeanor so long as it would not tend to identify the source. That's the only thing that has some weight to it. Then the information cannot be obtained by alternate means. I understand what that means. And then it goes on to say, or remedy less destructive of First Amendment rights, which I have no idea what that means, because the First Amendment doesn't provide journalistic privilege. So disclosing everything wouldn't be destructive of the First Amendment right. So what the hell are we talking about? I don't know what that means. And then subsection 3, which is even worse, there is compelling and overriding interest requiring the disclosure of information where disclosure is necessary to prevent injustice. I mean, that sounds like pretty open to a wide range of interpretations. Holy shit. Holy shit. Compelling and overriding interest requiring the disclosure of information where disclosure is necessary to prevent injustice. This is the part where I as theoretical judge hope very much. This is the part where I as theoretical judge hope very much there's precedent on this issue. And I can just go point to the precedent. Because if I have to figure out what this means, legislature, you can write the law. That would be great. That would be great if you tell me as the judge what to do, and I don't know what you want me to do, and I'm sad. Why can't you do your job better? Why is this my problem? Yeah. So, one is basically the only limiting parameter. At least you have to have all three of them. Okay, so determination. Oh, maybe it's going to give me some instructions. Oh, joy. Maybe this will help me. The district court shall consider the nature of the proceedings, the merit of the claims and defenses, the adequacy of alternative remedies, the relevancy of the information sought, and the possibility of establishing by other means that which the source is expected or may tend to prove. The court shall make an appropriate order after making findings of fact. The order may be appealed directly to the Court of Appeals, according to the rule of appellate procedure. The order is stayed and non-disclosure remains in full force during effective appeal. So we have an interlocutory appeal process. Thank God. That's somewhat helpful. When the court finds the information sought to have been published or broadcast, there shall be no automatic stay unless appeal is filed within 2 days. Either party may request expedited consideration. Yeah, that sounds pretty loosey-goosey too. I'm sure what to do. The prohibition of disclosure provided in subsection... What the fuck is this? What the fuck is this? The prohibition of disclosure provided in section 2.3, that's the major section, right? Yeah. The prohibition of disclosure provided in section 2.3 shall not apply in any defamation action where the person seeking disclosure can demonstrate the identity of the source will lead to relevant evidence on the issue of actual malice. That sounds unbelievably broad. Lead to relevant evidence? Lead to relevant evidence? That's 2 steps down. Not that it is relevant evidence, mind you, that it will lead to relevant evidence. So it doesn't apply in a defamation action where you can demonstrate the source will lead to relevant evidence on the issue of actual malice. So I kind of read that, and at least my first thought is, well, I guess there's no protection in the defamation cause of action. I mean, because that's so open. Will lead to relevant evidence? Notwithstanding the provisions of subsection 1, oh, you got to be kidding me. Exceptions to exceptions to exceptions to exceptions. We're now 4 levels deep, baby. We're exception inceptions. Bong. We're exception inceptions. We are 4 levels deep. We got exceptions. I hope you like exceptions. I hope you like exceptions because I got exceptions to your exceptions to your exceptions to your exceptions. I got exceptions for days. For days. Yeah. Notwithstanding that exception, here's an exception to the exception. The identity of the source of information shall not be disclosed unless the following informations are met. A, there's probable cause. There's probable cause to believe the source of information clearly relevant to the issue of defamation. That is definitely not what subsection 1 says. At all. Again, horrible legislative drafting. Horrible legislative drafting because you've created a conflict in the language choice between subsection 1 and subsection 2. Just great work, legislature. Again, you've created a conflict in the language. Before it was, how about all the people? And then you said, well, if it's a news media person, and you're like, wait a second, what? Is it all the people or not? And we've done it again. We've done it again because we can't legislate. We're bad at our job. We've done it again. Because in subsection 1, it says, will lead to relevant evidence. And then it says, there's probable cause to believe the source of information is clearly relevant to the issue of defamation. That is a lot more specific. Clearly relevant is a lot more specific than will lead to relevant evidence. So which one is it, legislature? Which one is it? Is it lead to relevant evidence or clearly relevant? Why do you suck at your job so bad? The information cannot be obtained by alternate means or remedy less restrictive of the First Amendment rights. I continue not to know what that means. I have no idea what that means. Less destructive of the First Amendment rights. What the hell does that mean? Less destructive to the First Amendment rights. Because as I've mentioned many times, there's no journalistic privilege in the First Amendment context. The federal government doesn't recognize it. So what does that mean? Less destructive to the First Amendment rights. What the hell is that? Does the legislature even know what they think they mean? Because I don't know what they mean. I got no clue what they mean. What the hell is that? How am I supposed to interpret that bullshit? And then I shall make the order on issues of disclosure. Okay. So, yeah, this is fantastic. Yeah. Fine. Recognition of reporters' privilege based on First Amendment varies between state and federal courts in Minnesota. No shit, Sherlock. The Minnesota Supreme Court has held no qualified constitutional privilege exists under the First Amendment that would protect reporters from compelled testimony in a criminal case. Ding, 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 ding. Right. It's not in the, yeah. However, Minnesota state courts continue to recognize some degree of federal constitutional protection for journalists' sources and materials. What? Further, the Supreme Court appeared to backpedal from this language in 2006 within the context of lawyer disciplinary proceedings. There, the court ultimately held that resolution of the case did not require it to decide whether the First Amendment privilege existed. However, in reaching this conclusion, left open to the door to future recognition of the privilege. It doesn't exist now, I can tell you that. Journalistic challenging subpoena for privileged material in Minnesota court should rely primarily on statutory privilege, but also discuss federal and common law privileges. Common law, yes, sure. Federal, yeah. Both to preserve the issue on appeal, I guess, because, maybe you will be the case. The U.S. Supreme Court will cite one, will create this privilege. So I guess, yes, you have to discuss the privilege that doesn't exist on the off chance that someday the U.S. Supreme Court will reverse that. Okay, yeah, all right, fine. The federal court has recognized a significant First Amendment privilege. Really? Most federal courts grant a qualified privilege for journalists against compelled disclosure of information gathered in the newsmaking process. Where a court finds the First Amendment rights of a reporter outweigh the requesting party's need for information, it typically extends reporters' underlying work product as well as identity. Most federal courts have assumed the privilege protects underlying work product. Reporter privilege is defeated only where this is again where things just get so fucked up. The reporter's privilege is only defeated where the information is critical to the maintenance of the heart of the claim, highly material and relevant, and unable to be obtained from any source. Which I'm just going to go ahead and simplify radically by telling you that there's no privilege in the federal system. Sure, it's privileged, except for where it is critical to maintenance of the heart of the claim, highly materially relevant, and unobtainable. And you can drive a truck through that. So, yeah. And then there's some other sources and stuff. Okay, so what we have learned from reading the statute on the fly. What we have learned from reading the statute on the fly is that Minnesota can't legislate. Minnesota's legislature sucks, which is unfortunately not a unique problem. They've created conflicts in their own language. Great. They wrote this really expansive policy and then created exceptions and exceptions to the exceptions and exceptions to the exceptions to the exceptions. And some of the exceptions to the exceptions to the exceptions to the exceptions use language that is conflicting. So, yeah. This is almost as good as the meltdown we had over pocket servers. The legislature can't write. It's their one job. It's literally their one job. It's their only job. Well, I don't know if it's strictly speaking their only job, but it's definitely their major job. The legislature, legislates. Their principal job in life is to write legislation, and they suck at it. They create conflicts in language. They create multiple exceptions deep, and I don't even begin to know what to deal with this. And I, as a judge, just hope beyond hope. My hope, as a judge, if I'm dealing with this bullshit, my hope beyond hope is that there's precedent I can cite so that I don't have to think about it. Because if I have to think about this bullshit, yeah. And also, there's absolutely zero probability, no matter what I do, the Court of Appeals won't reverse me. Because how the fuck am I supposed to get this right? It's a fucking mess. So, does Katie Joy have privilege? I don't know. I don't know we're any closer to answering that question than we were when we started the exercise. I'm not sure we learned anything of value by going through it. She might, maybe, could be, not sure. Yeah. Maybe you need the opinion of a Minnesota lawyer. He and Nick already went through it and couldn't agree. I don't. Yeah. Sounds like the Louisiana legislature. The Louisiana legislature is even worse. Louisiana is the most fucked up of the states. It is by far and away the most fucked up because of how they write their laws. Because of how they write their laws, they're the most fucked up. Okay. Here's the problem. All right. Here's the problem. Louisiana is not common law like the rest of the country. Like the rest of the country gained its legal tradition from England and it's common law. This I understand. Louisiana over here, of course, got its legal tradition from the French because it's Louisiana. You know, France bought the land from France. Louisiana Purchase. Anybody? Bueller? Yeah. Okay. So what is the difference between civil and common law? Good question. The principal difference between civil and common law is that binding precedent isn't really a thing in the civil law system. Okay? So in the common law system, we have binding precedent. That is, when a court rules on an issue, right? When they rule on that issue, when they reach a legal determination, that's precedent now. And if it's from a court above you, it's binding precedent, right? So I have to go do that thing now, right? So the law builds on itself from case after case and clarifies itself from case after case, which is good, for example, for me as a lawyer, because it makes it much more easy in many circumstances for me to give you better legal advice, right? Because I just don't have the statute. I've got precedent. And depending on what we're talking about, I got hundreds of years of precedent. Depending on what we're talking about, I might have longer than that, right? Because this has been building on itself for a little while now, right? So depending on what we're talking about, I might be citing cases from the 11th century. I'm like, well, I can give you a pretty damn good idea of what it is. I got 900 years of case law. Where do you want to start, right? This is very good for me as a lawyer giving legal advice because the case law builds on itself and it raises, and fewer questions emerge, right? As issues get resolved by the courts, fewer and fewer issues remain. And eventually there basically are no issues left. And it's just application of the law. This is great. Louisiana and the civil law system, in its infinite wisdom, has decided, hey, what if we just, don't do that? What if we didn't have precedent? What if every time judges interpret our laws, what if every time they read it, it's like the first time anyone's ever read it ever? What if we just go with what the legislature wrote, and every time we have to interpret it anew? And judges might be able to go look at what other courts have done, but they're not binding, as I mentioned. So the judge can kind of just do anything. Then it gets even worse. It gets even worse because, oh, Lord have mercy. Because Louisiana, again, in its infinite wisdom, because of these problems that I just mentioned just now, the easiest solution to this problem would be, hey, you know what? What if we weren't a civil law system anymore? What if we were a common law system? That would be the easiest solution to the problem. But no. We can't do that because we're very French and very proud. So we can't do that. So what if we amended the Constitution for literally everything? What if our Constitution wasn't, basically 4 pages scrawled out on the back of a napkin, which is essentially the federal Constitution? What if instead, hear me out. What if instead of like overarching ideas and broad principles and establishing the branches of government, what if it specified everything in amazing pinpoint detail? What, those problems about water reclamation we're having? What if we put that into the Constitution? Yeah. So, as an upshot of that, Louisiana has the longest constitution in the world. In the world. Let me find out how long it is these days. Well, it's 135 pages. That's promising. Yeah. It goes on for a while. 135-page Constitution. I think it's like 230,000 words. It's ridiculous. So yeah, these are some of the problems of Louisiana. Its legal system. I think the rest of the country just cumulatively looks at Louisiana and be like, oh, really? And then also, just to make even life more fun, Louisiana apparently doesn't like to do things the rest of the country does, just because it wants to be different. Like, for example, in the sale of goods, there's something called the Uniform Commercial Code. Mm-hmm. The Uniform Commercial Code deals with the sale of goods. The sale of goods, the law regarding sales of goods is controlled by state law, right? What is a purchase? What is a purchase? What kind of protections are there at law, right? Are there any kind of warranties provided by law, right? What if you order something and you didn't get what you ordered? What do you do then? What if something unsolicited arrives at the door? What happens then, right? These are good questions. These are very good questions. And these are all issues of state law. So in the long, long ago, in the far, far away, all the states had their own individual law dealing with this. And, that's fine because they can. And, but it was a little inconvenient, especially as national sales became more and more of a thing, right? As catalogs for like the average home user, like Sears, became more a thing. As people were ordering more stuff from telephone, as people were ordering more things through the mail, instead of just going to their local store, right? In the long, long ago, in the far, far away, if you wanted to buy something, you bought it from the local store. Circa 1950, people start doing things other than that. And this becomes a bit of a problem. Because now suddenly we have sales going across different state lines, and we have different states with different rules. And this is a little annoying. This is a little annoying for everyone. Okay? So someone got together and said, what if instead of every state having different rules, what if instead they all had the same rules? And then, that'd be great. And then all the states would have the same rules, and it'd be fantastic. Hooray. So somebody wrote the Uniform Commercial Code. Incidentally, they've written other uniform codes. The Uniform Commercial Code isn't the only uniform code. It's the one that's been the most widely adopted, but it's not the only one. But it's the one that took off, right? It's the one in which state after state after state said, yes, let's pass a law. Let's pass a law and says, you know what? All our state law on the sale of goods is bullshit. All of our state law on the sale of goods is bullshit. What if instead of all the state law we've ever had, what if instead of that, we had this new thing, this Uniform Commercial Code? And what if we had that? That'd be great. And so state after state said, yes, I'd like to abolish all my law. All my law sucks ass. I'd like to establish the Uniform Commercial Code. And guess what state said, nah, we're good? Guess what state said, nah, we're good? We like our law we like the law we had before. We don't need that stinking UCC too. We don't need to adopt the thing that 49 other states have adopted. We don't need to have the uniformity. We're good. We like our own law. Yeah, that's great. That's fantastic. That'd be great. So, yeah. Louisiana is special in every possible sense, including the unflattering ones. So, yeah. So, Minnesota doesn't know how to legislate, and Louisiana thinks the way to legislate is putting everything into their constitution and being different from the other kids. And then Stephanie points out, yeah, this is also the same state. This is all because they have drive-through alcohol bars in Louisiana. You can get to go pre-made drinks in Louisiana. You can get in your car and you can go to a drive-through bar and you can order a margarita and they'll give it to you mixed in a cup like a drink for your car. Now, Louisiana, of course, being master of its own law, doesn't have to have drunk driving laws. I mean, they could say, how about not the drunk driving laws? We like it when people drive drunk. They didn't go that route, fortunately. They didn't go with the we like drunk driving route. So that's good. They could also go with how about we just don't have open container law? You know, it's totally fine if you have an open beer in your car. That's fine. That's cool. You know, you can't drink from it because we don't like the drunk driving. But if you have an open container of alcohol in your car, that's totally cool with us. That would have been an option. Louisiana didn't go with that option. Louisiana said, you know, we don't really like the drunk driving, and we don't really like it when people drink or have an open container in their car. We're not really huge fans of that. But we also like the drive-through bars where you can order the margarita in a cup that will fit in your cup holder. So how do we solve this twin problem? And the state of Louisiana, in its infinite wisdom, said, you know how we can solve that problem? What if, when they give you the drink with a straw in it, and hear me out, what if we put a sticker over the top of the straw? Then it won't be an open container, you see, because of the sticker. Okay. Yeah, that was Louisiana's solution to that interesting dilemma. Yeah. What if we just put a sticker on the straw hole? Yeah. Louisiana does have open container laws. I didn't say they didn't. I in fact very specifically said they didn't. Yeah, Louisiana does have open container laws. That is true. I didn't say otherwise. That would have been an option. What if we just don't have the open container laws? That would have been great. But they didn't go with that choice. They went with what about the sticker? And we can have our drive-through bars. Okay. That's fine. Okay. Yeah, it's fine. Put a sticker over the gun. Cute. It's that way here in Texas too. Well, I haven't run into any drive-through bars, but maybe. Yeah. So, yeah. So, if whether or not Katie Joy Paulson has journalistic privilege is an exercise best left to the judge in the case, and who knows? I don't know. But the discovery dispute itself is a nothing burger because it happens all the time, although annoyingly. I'm going to sign off If you've liked the stream, please remember to like, comment, subscribe, do the YouTube things. I'm going to head out. Until later, my friends. I hope all is well. Cheers and goodbye.